Hello, and welcome to another installment of VLF's video education series. Today we're discussing record-keeping requirements under the Fair Labor Standards Act, the FLSA.
So under the Fair Labor Standards Act, or FLSA, it is the employer's burden to keep records of time worked. So Joe, what are we looking at as far as records for the hours worked?
Well, the employer has to keep accurate records, which would mean time cards or some sort of punch-in, punch-out system or some other method so that the hours can be accurately recorded and it can be determined whether or not overtime is due.
So gentlemen, what are the types of records that an employer must keep to meet its burden of having employee records of a work week on a weekly basis?
As Mr. Lanza mentioned, you have to do it on a week basis, which means what you can't do is, for example, you pay every 2 weeks, is say, well, over 2 weeks you worked 80 hours, you might have worked 45 the first and 35 the second, so we're going to pay you just straight time. That would be a violation.
Right. So these cases wind up in court. We're seeing a high incidence of litigation concerning the Fair Labor Standards Act. You also have employees who file these suits just arbitrarily claim that they've worked 60 or 70 hours a week. What's an employer to do? What's recourse to that?
Well, if the employers kept accurate records, they have evidence to show that. However, if they haven't kept accurate records, unfortunately, they're going to be in a bit of a predicament because the court, and I'll let you talk about this, Joe, can make an inference to the employer's detriment.
So how's that work, Joe? How's that inference work?
Well, as Joseph said, the burden is on the employer to come forward with adequate evidence of accurate hours kept. If that doesn't happen, the burden then shifts to the plaintiff, who would be the employee, to bring forth evidence from which the number of hours worked can be reasonably and justly inferred by the court.
So what if they just have a sworn statement saying, I work 70 hours a week and that's it, nothing else? Is that going to be sufficient?
That may be enough depending on the state of the employer's record. If the employer failed to keep any records whatsoever, and that does happen from time to time, then the sworn statement by a plaintiff may be sufficient.
Joseph, you mentioned the hours that are worked in a work week. What is the maximum number of hours an employee may work before overtime is incurred?
40.
Okay, straight 40.
40.
So what's an employee to be paid if he or she works more than 40 hours a week?
Well, then every hour of additional work requires the payment of an overtime premium, which is calculated based on that particular employee's regular rate during that particular week.
And to reiterate, Joe Lanza, if the employer does not have records on a weekly basis of the hours the employee works, then can a court consider the naked statement of an employee?
A court can consider the naked statement of an employee, although I will point out that rarely do you have a complete vacuum of evidence other than a statement by an employee.
Okay.
As we know, the rules are changing over time in the FLSA. In the most recent administration of the president, a lot of rules are taking effect in December. And some of those rules, while not necessarily addressing record keeping, do impose higher penalties, increasing the required weekly salary to fit into certain exemptions. So record keeping, for example, maybe you don't keep time records for your managers because you assume they're exempt. Well, that might be an issue in 6 months.
All right. To learn more about record-keeping requirements under the Fair Labor Standards Act, please visit our website at bethanlaw.com.
Your problem is our business.
We'll see you next time.